We've got Pepper Crutcher, attorney, Balch Bingham, in the studio. Full disclosure, of course, as I always do, Pepper, longtime friend, longtime confidant, and legal counsel throughout our business relationship. A very valuable member and partner of the team in that regard. Pepper called me a couple of weeks ago to alert me to this bill that was traversing through the U.S. Congress, and did some research on that after he alerted me to this thing coming up. So, Pepper, welcome, and give us the background on this bill and what this thing means.
Well, if you are an employer, as you used to be, and you have a system of arbitrating by contract your employment disputes with your employees, then thanks to the Federal Arbitration Act, up until February 10, 2022, you could enforce that to make your employees arbitrate instead of going to court against you, even in the case where a claim involves sexual harassment or sexual assault. Thanks to H.R. 4445, passed February 10, with bipartisan Republican support in the Senate, by the way.
Yes, I'm looking at that, yeah.
You will no longer be able to enforce your arbitration system if you just leave it as it is. To make people go to court, to stop people from going to court against you, if there is anything about the dispute that relates to sexual harassment or sexual assault. So it doesn't affect only cases that allege only sexual harassment or sexual assault. The law literally says if anything in the case relates to sexual harassment or sexual assault, then employers can enforce their arbitration systems and employees get to go to court. Bypass the arbitration system. Now, what do you think is going to happen?
I teased it in the last segment. Go ahead and tell them.
So, I really admire my entrepreneurial trial lawyer friends, and I know what they're going to do. So, they can have a 70-year-old white male plaintiff, and something in the complaint is going to allude to some incident of sexual harassment or sexual assault, so they can bypass the arbitration system because they hate arbitration.
I can see the conference now. But you were sexually harassed, right? Right. Well, like one time at the water cooler, they came by and pinched you on the butt or something like that.
Now, what'll happen is if it's a male plaintiff, the male plaintiff will say, well, 10 years ago I ratted out my fellow male manager for sexual assault, and you bided your time, but you eventually got me for doing that. And literally, on the way this bill is written, that would bypass the employer's arbitration system.
All right. So, for the benefit of the audience, why, Pepper, would an employer and perhaps even an employee, as part of their contract, part of their terms of their employment agreement, why would they opt and want to seek arbitration as a primary means of settling, or certainly the first approach to settling a dispute, versus just go straight to a lawsuit and into court?
Well, when you hear somebody say it's not about money, it's about money.
Sure.
It's about money. So in litigation, time is money. The longer any lawyer works on something, the more it's going to cost for that lawyer to finish working on it. The great advantage of arbitration for both parties is that it typically takes a fraction of the time to resolve an employment claim in arbitration that it takes to resolve it in court. And that's before all the COVID delays in the court dockets.
Yeah.
So you're looking at now probably 2 to 3 years to resolve an employment claim in a federal district court. You probably get that done in 6 to 9 months in arbitration.
Who typically serves as arbiters?
Leaving aside the world of labor contract arbitration.
Okay.
The typical people serving as arbitrators are lawyers who have some experience in employment law, or people who used to be judges and as judges got some experience with employment law.
Okay.
They tend to be older people who are semi-retired or retired. And the very successful ones tend to spend a lot of time on flying around the country hearing cases.
Arbitrators, not arbiters, my bad. So
same thing.
All right, so I've been through one of these before, and for those of you that haven't, I'll explain kind of what those look like. You get the two parties in separate rooms That's been my experience.
That's a mediation.
Okay, that's mediation, not arbitration. Okay,
yeah.
The difference, please.
This doesn't apply to mediation.
Help me understand the difference.
So arbitration is like going to court. The ruling is final and binding. Now, you can appeal it to a court under various statutes that control appeals.
Okay.
But when you get a judgment called an award from an arbitrator, that's like getting a judgment from a court. You've agreed that it's going to be an effective, final, and binding as to you, subject to any appeal rights you might have. That's arbitration.
All right. So let's get back to this particular subject, which deals specifically with sexual harassment. I mean, that's what the law. Is it a law yet? Has it been signed?
I don't know if the president has signed it yet, but he's going to sign it.
Yeah.
Sexual harassment, sexual assault, and it also has a section about pre-dispute waivers of the right to bring a class or collective action. So one of the things that an arbitration agreement for especially a large corporate employer says is, hey, you can't sue us as a member of a class or a collective action. You have to bring only your individual claims. Well, this outlaws that too.
Okay. Yeah. All right. So what's the purpose? What are they looking for here? Why do they want to force this into court and not allow arbitration?
What Republicans were motivated by and agreed on is that it is morally wrong and it ought to be legally wrong for serially abusive executives to use arbitration and confidentiality agreements to keep the rest of their female workforce from finding out what they're doing.
Okay, got you.
Everybody agrees on that.
Okay.
And if this bill had only done that, people like me wouldn't.
No question.
Yeah. But sadly, this bill creates lots of incentives to throw bogus sexual harassment, sexual assault claims into lawsuits that otherwise wouldn't have them as a way to bypass arbitration.
Is this the Me Too movement driving this, do you think? Your opinion?
Yes. Yes, but it's also, for good Republican moralists, it's we shouldn't allow Jeffrey Epstein to get away with it. We shouldn't allow Harvey Weinstein to get away with it, and we ought to be part of stopping them.
Okay.
Yeah.
All right. And now all kinds of revelations about the ousted Chris Cuomo at CNN. Looks like he's got his hands full. No arbitration there.
I can't tell my favorite CNN joke on the air. I just heard it recently. It involves that.
Oh, my
I'll tell you out there.
All right. So how might this change the outcomes of these disputes? Arbitration versus going to court, full-blown lawsuit.
Well, employers who have relied on their arbitration system as a way to manage their risks are going to have to either redesign those systems to address this amendment, or they're going to find those systems increasingly useless, and they're going to experience a spike in their sexual harassment claims.
Yeah. Okay. You got to believe that's going to be the case. So now what you are telling us is that this law would invalidate those provisions in existing agreements. Is that correct?
Yes. With regard to claims of sexual harassment, sexual assault that arose on or after February 10, 2022. If something arose last year, you can still enforce your agreement.
Wow. So the government just steps in and says, hey, employer and employee, these agreements, these gazillions of agreements you have in place, which provide for arbitration to settle disputes between the parties of employer-employee. Well, when it involves sexual harassment, sorry, that doesn't apply. You got to go to court. I mean, am I reading that right?
Well, no. Employees could still choose arbitration if they wanted.
They have
don't
an
have
option.
To.
Okay.
But here's the conversation that I think is typically going to happen, and I sort of feel sorry for women who are going to be subjected to this conversation. You've got a case that's, let's say it's about age, or let's say it's about race, or something else, and it's sort of an iffy case, something a lawyer might want to take, might not, but if he's got to go to arbitration, absolutely not going to take it, because lawyers are in this hoping for the lottery verdict in the jury trial.
Yeah.
So the lawyer says to you, if you can think of a sexual harassment incident you suffered at some point, I might be interested in taking this case. If you can't, I'm probably not your guy. Okay. Now
about money. It's about money.
When they say it's not about money, it's about money.
I hear you. Oh my gosh! Well, all right. So we'll figure out whether or not. But you're right. The president's going to sign this. It passed on a vote in the House, 335 to 97. All the no votes were Republicans. I guess my objection here, and we got to go. But my objection here is it's just government getting in my handbook again. I just don't like that.
Well, get used to it.
Sucks. I'm sorry. Pepper Crutcher with Balch Bingham has been our guest here on Middays. We shall take a break right here. We'll come back with